And welcome everyone. I'm Rafael Carmona from the ICDR, and I also work in our Young Practitioners Group, the ICDR Young and International, or YNI. And I want to, again, welcome you to this webinar and just take a moment of your time to remind you that you can join as a YNI associate. If you visit our website, you can Google ICDR Young and International and you will find us. And in our website, you will find registration forms in English and in Spanish, as well as recordings of previous webinars that we've organized. You can also join our LinkedIn group. Again, if you look for us, ICDR Young and International, you're going to find us and you can request to join the LinkedIn group. We'll also be posting all of our updates there. With that, I will very briefly introduce our moderators today. Irina Akulenka. Irina is a qualified engineer with 15 years of experience, including 7 years of managing construction and engineering projects, and more recently in contractual claims preparation and defense, as well as disputes work, expert work, and alternative dispute resolution. Irina is a fellow with the Chartered Institute of Arbitrator and acts as arbitrator in construction disputes. Our second moderator is Anya Marinkovic. Anya is an attorney with the California Bar and a senior associate at the Swiss law firm Behr & Carrere. She acts as counsel and arbitrator in international commercial arbitrations with a focus on disputes in the construction sector. And both of them are part of our YNI Global Advisory Board. And with that, Anya, Irina, the floor is yours. Thank you very much.
Thank you, Rafael. And we also have Luis Martinez from the ICDR here online, who will give us a few introductory remarks before we get to our panel. Thank you, Luis.
Thank you very much. And I really want to congratulate the ICDR Young and International Executive Board and the Global Advisory Board and their leadership for putting together this very successful, probably one of our most successful 4-part series on international construction. From the level of attendees, we can see that the interest has been incredible throughout the world. And this is actually the 4th in the 4-part series, which, as the other 3, is being recorded. And you'll find all of them posted on the ICDR Library of Recorded Programs. So we do invite you to visit if you haven't attended the previous 3. Now, from the ICDR's perspective, international construction is year in and year out one of our largest international and domestic caseloads. We in the international division work closely with our colleagues in the American Arbitration Association's construction division. We have a number of joint initiatives that we've been looking at promoting our alternative dispute resolution services in both markets. We have spent a great deal of time focusing on really what our philosophy is for this caseload, that global expertise matters and that you need decision makers who are well-versed in the intricacies of international construction. So we have several panels. We have our construction mega panel. We have our international construction panel. And you can find a great deal of information on these rosters on our website. Currently, we are also working on updating our dispute review boards and dispute adjudication board procedures. We've been going through them, updating them. We're focusing really on dispute avoidance as a core concept that will be found as you go through those procedures, and we hope to have them released early next year. So just again, thank you for joining us. It's been interesting, these conferences, and I've gotten the opportunity to learn a lot. And let me turn it back over to our moderators, Irina and Anya.
Thank you very much, Luis, for those introductory words. And good afternoon, good morning, good afternoon, good evening to everyone that's joining us. I now have the pleasure of introducing our panelists for today's webinar. The first panelist we will hear from today is Professor Stephen Shapiro from the Washington College of Law at American University. He is the director of their hospitality and tourism law program and teaches a course on construction law. He also sits as arbitrator for several international arbitration institutions. Our second panelist is Nader Emile, who is a director and regional manager with HKA based in Saudi Arabia. He is a legally qualified civil engineer with 20 years of experience in the construction and engineering industries. Nader currently provides claims consulting and delay expert services, including planning advice, forensic delay analysis, and arbitration support on a wide range of complex projects for clients in the Middle East and Africa. We will then hear about disruption claims from China Irwin. China is counsel at La Live in Geneva, specializing in arbitration, including both commercial and investment treaty arbitration, with a focus on complex disputes involving major construction projects. She is also the deputy editor of Construction Law International, the quarterly magazine of the IPA's International Construction Projects Committee. And finally, we have Sean David Yates, who will be addressing the issue of acceleration. He is an English barrister and general counsel at China State Construction Engineering Corporation in the Middle East. He was called to the bar in 1996 and relocated to the UAE in 2006, following 10 years of practice in common law, in a common law set of chambers, undertaking civil and commercial work. Sean is a member of the Chartered Institute of Arbitrators and is registered as an arbitrator with the Dubai International Arbitration Center. So without further ado, we can now get started with our discussion of the very interesting topics of delay, disruption, and acceleration, which are core concepts, of course, for all of those interested in construction disputes. We will try to save some time at the end of the webinar for questions from the audience. So please feel free to share your questions in the chat function, and hopefully we will have time to take up some of them at the end. And our first question today is for Stephen. So in order to give our listeners some context for the discussion, could you give us an example of a factual scenario that could lead to claims for delay, disruption, and acceleration, and a brief overview of standard contract terms that deal with these issues? I will put up the slide that you have prepared for us.
First, I want to thank ICDR for inviting us and the Y&I. Also, hopefully at the end, we can put up my LinkedIn page link and invite everyone to connect with me. Okay, so I'm going to try and set the stage. I'm thinking of a small commercial office building, very basic schedule and logic rather. So the brick and the skin is going to take 80 days to install. After that is the roof is going to take 20 days to install. And then the windows take 5 days to install. In this fact pattern, I have put that windows arrive 10 days after the order is placed. So in this case, we have until day 90 to order the windows. We have a 105-day schedule, and my colleagues will talk about what happens with that 105 days. But in my example, windows need to be ordered before day 90. I'm going to keep it simple, and that the windows are ordered at day 100 instead of day 90. So we have a 10-day delay. So instead of delivering this project on 105 days, we're delivering it at 115 days, 10 days late. So what are and this is obviously a simple example, and we can take this example forever in construction projects. There is a cost. Two parts to my conversation. Why was it delayed and what are the costs? Let me start with the costs. For those watching, the only term I think I would try to remember or write down is general conditions, which are the administrative costs to the general contractor, the salaries of the project managers, superintendents, and they are considerable. For those extra 10 days, the GC, the general contractor, has to pay general conditions. On the other side is the owner. The owner is 10 days late getting this commercial office building and is going to lose potentially 10 days of rent. So those are the costs that will be, my colleagues will be examining. So why were the windows ordered at day 100 and we had all this time? For right now, I'm just going to call this float, even though it's not the precise. We had 90 days. So was the owner slow in approving? Was the architect, which is typically the owner agent, slow in specifying? Or was there a delay by the general contractor? I usually have a bias towards the general contractors, but they can be slow, they can forget about it. And I'm going to stop there. I'm just going to introduce that there was an error. There was a slowness that cost 10 days. So we're delivering at 1:15 instead of 1:05. Anya, I'll stop there and then circle back once we've had everyone go through, unless you have any questions for me to follow up with.
No, thank you, Stephen. That's perfect to set the stage. And I'm going to take down the slide and hand over to Irina, who will discuss delay with Nader.
Thank you very much, Anya. Well, hello, everybody. Pleasure to be here and thank you for this webinar. So from Stephen on the scenario that is, quite possible to take place on any given site, and about possible issues that can arise on a given project and cause project delays, or we say cause issues with project progress. Now, if we talk and now that if you can tell us, terms, but let's say in simple terms, what is delay? And what are the different types of delay that can be possible? There are always confusion about concurrent delay, critical, non-critical, non-excusable. So if you can tell us a bit about those.
Hi, everyone. Thank you, Irina, for this. Thank you for the ICDR and everyone. This sounds as a very simple question, and I will try to wrap it up very quickly in the time allowed. In fact, when we talk about delays, construction project delays, we will have to distinguish between a non-critical delay versus a critical delay. And this will come when I explain some of the definitions or go through them. Some of the definitions of a project delay are better than others. For example, we can have a delay is where the works are not performed during the time specified, or a situation where the project cannot be completed during the planned period, or a deviation from the originally planned period for completion. Sometimes we have other definitions like the projected or actual time overrun beyond the contract date. So as we can see, we have many definitions, and we will have to observe the definition in the contract, in the relevant contract at hand. So the main thing is that a delay could be impacting the works or the activities in a schedule, but does not have an impact on the forecasted or the actual overall project completion, and this will be called a non-critical delay. This basically will depend on the float in the program, which is the amount of time allowed for an activity to be delayed without delaying the overall project completion date or the overall period of the project. So a critical delay is a delay that is going to impact the critical path and is going to delay the whole project. And here, sometimes we are dealing with a project that is completed or a project that is not yet completed. And we will come to this when we talk about the other types of delay. So in terms of the responsibility of the delay, we will see that we have inexcusable delays. And these are delays caused by the contractor or the subcontractor or the supplier or otherwise whereby no relief is available according to the contract. And in that sense, a party or the claimant, probably the contractor, may incur damages like liquidated damages or actual damages, unliquidated damages. And excusable delays, on the other hand, are the delays that are usually beyond the contractor control. or the subcontractor's control, and without the fault or negligence of the contractor himself. An example is some unforeseen conditions, errors and omissions in the plan from the part of the employer, some late response from the part of the employer or late approvals. All of these are beyond the contractor's control, and he has to be excused. And the implication is that there will be a recovery of time, or an extension of time would be granted. And there will be a relief from paying the delay fines, as we call them sometimes in the Middle East contracts, or the delay damages or liquidated damages. If the delays are not critical, then it doesn't really matter. But if they are critical, then we will have to allocate a responsibility. And if they are excusable, then we will have to ask ourselves another question about the different categories of these delays. Are they compensable or non-compensable? Because an inexcusable delay naturally is non-compensable. So what is compensable is a delay that is compensated for. The contractor will be compensated for the indirect costs that are incurred as a result of the prolongation of the duration of the project. And usually this is from delays that are caused by the employer or the owner himself, or the party receiving the works. It could be the contractor versus the subcontractor, and in that case, the contractor is the party receiving the works. So the contractor is going to be compensated for the extra costs incurred as a result of this delay. And usually we have other events that also qualify as excusable delays. However, they are non-compensable. And these when they are not caused by the employer itself. When they are not caused by the employer, he does not need to compensate the contractor because it is not his fault. So some delays, as we call them, third-party delays, neutral delays, or force majeure, then they are excusable, that they will grant the contractor an extension of time. However, he will not be compensated, and therefore they are non-compensable. So another type of delay is that it could be excusable and compensable, or caused by a compensable event. However, they will not be, there will not be any compensation because the contractor has his own concurrent delays. So now the subject of concurrency is a very wide subject. And just to summarize it, it is when the contractor has impacted the project or caused delays that were running concurrently with other delays. In very simple terms, it is when the contractor and the employer caused the same delays to the project or overlapped delays. In that case, the contractor will only be compensated for the period in which there is no overlap, or the period where he was not the reason or the responsible for the delays. And if the contract will allow, he will be granted an extension of time with no cost. And this is a very famous case where the employer always argues that the contractor is in concurrent delay and therefore he will not be compensated. And then we will have to look for the definition of what is a concurrent delay as per the contract. Also, we will have to ask ourselves how it is to be identified or calculated, and what are the implications. So all of these questions need to be taken into account before we jump into strict conclusions. This is in very general terms what is a delay, a project delay, and what are the different main categories of that according to the impact on the critical path, according to the responsibility, and according to the implications. I hope that was clear and brief.
Thank you, Nader. I was actually going to cut you there, but I will take 2 minutes from you on your next question. No, I'm just kidding, of course. It was very helpful, I think, to sort of understand the importance of criticality aspect there, and also to understand how liability plays, you know, against the costs and who is liable for what and when and why. So thank you very much for that. Now, if we can talk about different methods of assessing delays. And perhaps you can also tell us about the applicability of different methods when, you know, prospective methods best to be used or not to be used.
Very good. This is a very interesting question as well, because people here use different definitions. When we talk generally, very generally, about what is a prospective method versus what is a retrospective method, then we usually talk about that the prospective method identifies the likely or the predicted impact of the historical progress or delay events on a completion date. Whereas a retrospective delay analysis, again, very generally, we mean that this is an analysis that identifies the actual impact of the delay events on the completion of the project, or on the impact on the as-built critical path, which actually happened. So this is very broadly. However, we have to make sure that when we talk about prospective versus retrospective, other elements come into play. We need to understand what we qualify here. Is it the timing of the analysis that is retrospective, or is it the extent or magnitude of the delay event, or the duration of the period of influence of the event? Is it retrospective or prospective or retrospective? Or are we talking about a retrospective versus retrospective impact on the critical path? Or are we talking about the determination of the critical path itself? So all of these elements could be determined retrospectively and prospectively. So this will take us to different methods of delay analysis. Generally, we have 4 main methods, and these could be categorized under 2 main categories or groups. One is the observational techniques, and sometimes we call them backward-looking techniques, and versus the modeled techniques, or where we use simulation or impact using what we call fragments in technical terms. So these are forward-looking techniques, and they could also be described as prospective. So what is the issue here? The issue is, are we using, is the project already completed? Is the event already, has the event already occurred? Because sometimes the project is not yet completed, but the event has occurred, and we can assess the full impact of the event, but on the critical path. And the critical path itself could be prospectively or contemporaneously determined. So this is not a full retrospective method of analysis. Talking about the methods, we have 4 main methods. The impacted as planned method, which is using a purely prospective approach to assess the critical path. And this happens in the very beginning of the project. It depends on the baseline schedule or program, and then we impact this program, which is a forward-looking or model technique, by fragments to simulate the impact of the event or the delay. And then the difference between the impacted versus the non-impacted is the extension of time entitlement. Another method which is more developed is the time impact analysis, which is almost the same technique, but we use updated programs right at the start of the event, so that we can rule out previous delays or previous issues from other events. And this will be more determinative of the extension of time entitlement. Another method is the as planned versus as built, and this falls under the observational category, or the forward-looking technique. Basically, we have 2 programs: as planned program, which is the original plan, and as built program, which is the actual after realization of the whole project. We simply observe the 2 programs, and we compare the critical path together, and we see where the events have happened and where the delay occurred. This is an observational technique. And another backward-looking technique, but model technique, is the collapsed as built. Is basically the exact reverse of the impacted as planned. We just take the as built program, we create a collapsible as-built based on the program logic, and then we start implanting the delay periods there within the network of the program. And then we subtract or extract, remove these periods of the delay, and the program will collapse. The extent of the collapse will basically determine the extension of time of the contractor. The last thing before I conclude this is that we have the Windows analysis or the Windows approach. And this is not an isolated analysis in itself. It is just an approach we can use with the time impact analysis or the as planned versus as built or any method. So when we use this, it becomes more indicative and provide further detail as to how the delays happened based on how the criticality has been assessed. In very general term, these are the 4 basic methods. And of course, we can have different variations and we can have plenty of methods to assess the delay.
Thank you so much, Nader. That was very informative, but maybe too many technical details for one session. So I'm seeing also some questions on the chat. For those of you who want to know more about the methods, you can always refer to SCL protocol, as we call it, on delay and disruption. And there is a bit of information in there. So I'll hand over back to Anya now.
Yes, thank you. And thank you so much, Nader, for all those really interesting and detailed explanations. We will now move to the topic of disruption, and I'm going to ask China. Since delay and disruption can sometimes be confused and conflated, and it may be difficult to understand how an event causes either delay or disruption or both. Can you tell us what is the difference between disruption and delay? And I will, share my screen again with your slides that we have.
Great, thank you. So we've already heard a very good explanation of delay. In the simplest terms possible, disruption means that the work is carried out less efficiently than it would have been if the disrupting event or events hadn't occurred, and that the contractor has incurred additional costs as a result. So on the slide here, I have put the definition from the SCL protocol, which, as Irina mentioned, has come up in the chat, and it is a good source for some relatively simple explanations. So the major difference between a delay and a disruption claim is, of course, that in a delay claim, the end all be all is to show critical delay. Whereas in a disruption claim, there doesn't have to be critical delay. In fact, actually, the work might have started and completed in time, or it may be that the disrupted activity wasn't on the critical path, but the contractor has still incurred additional costs due to the disruption. The other big difference is the losses that you're claiming. So you might claim an EOT, an extension of time for disruption, but you might not. And whereas for a delay claim, you're going to be looking at the time-related or prolongation costs. In a disruption claim, you're not claiming time-related costs. You are claiming the additional costs for a unit of work. So you're going to be looking at labor costs and equipment costs. So to make this more concrete, I'll give you quickly, two simple examples of a disruption claim. So if a contractor has, for example, planned to carry out a certain work in the dry season in the country where the project is being done, and let's say the employer was obligated under the contract to take care of getting the permits and approvals needed, and they're late in doing that. And as a result, the contractor is not working in the dry season, but they're working in the rainy season. So therefore, they're having to start and stop their work according to the weather. Now, again, maybe this makes them late, but maybe it doesn't. Say, for example, they pull in extra teams to do night shifts when the weather is good. Another example, if a contractor is working on a project that's multiple structures. So let's imagine there's apartment buildings and then office building that goes with the apartment buildings. Now, if the employer was supposed to provide the design and they give the design for the apartment building on time, so that can go ahead, but they're late on the design for the office building. But the contractor may have planned to do the works in parallel to most efficiently use teams and equipment. So let's say they wanted to do the excavation for both, and then the concrete work for both, and then the MEP for both and so on. But as a result of this problem, they have to go forward with the apartment buildings, and then they have to either keep longer or bring back later the same teams and equipment to do the office building, then that would give rise to a disruption claim.
Thank you. That's very helpful. And then that brings us to a disruption claim. And when you're seeking compensation for these costs that you've discussed, what does a contractor have to prove, and what type of evidence is a contractor going to have to present to show that they've either thickened the resources or had to change the plan in some way due to the disruption?
Yes. So Nader might disagree with me because he's got the expert perspective and I've got the lawyer perspective. But I personally find disruption claims much more difficult to make, and they're normally not brought by themselves, but they're with delay claims and other claims. So there's three basic elements. You have to have a legal basis, you have to have the existence of a disrupting event, and then you have to establish causation. So I'd say for the first part, that's really the lawyer's job. The second part, that's where we rely on experts. And the third part is kind of a mix. That's where the lawyers and experts need to work together. So for the first, there has to be a legal basis. You can't just say I had additional costs, so I'm entitled to my additional costs. There has to be some kind of a contractual hook. But this can be something very basic. For example, a contract might have a provision that the contractor is to be compensated in case of breach by the employer of any of the provisions. The FIDIC conditions, which are widely used and we work with a lot, they don't have anything specific about disruption, but they do have many provisions about potential sources of disruption. So for example, the employer failing to provide timely site access or unforeseen physical conditions. And these clauses provide that the contractor can claim costs. So that could be the hook for your disruption claim. The next one, one more is variations. If the clause provides that the contractor is entitled to the cost impact for a variation, that can also be used for a disruption claim. Okay, so the next one, the existence of the disruption, and I should probably add to this, and the loss of productivity. So you have to show that there was actually disruption, the contractor has to have some kind of baseline to work from, and that's the level of productivity they would have had if the event hadn't occurred. So one way to do this, you might think simply, would be to say, okay, let's look at our planned productivity as per the tender and our actual productivity as per daily, weekly progress reports. But that is quite problematic because it invites a big debate about whether the planned productivity was reasonable in the first place. So maybe the contractor actually really underbid for the project. The most widely accepted method that tribunals and courts are most comfortable with is something we call the measured mile approach. And that's where you look at the productivity that was actually achieved on the same project, either for an undisrupted time period or for an undisrupted work activity that you can compare. So to give the simplest example I can think of, if you're building a road, 100-kilometer road, and there was a disruption at kilometer 50 to 100, but not at 0 to 50, you might say, okay, let's compare the progress on 0 to 50, the productivity to 50 to 100. But this obviously isn't always possible. That's a perfect world. So maybe there was disruption from the beginning, so there's not a problem-free area you can look at. Or maybe the work activities aren't exactly similar. So to go back to the road, okay, the road is the same, but the geotechnical conditions are different in different parts of the road. And then obviously you wouldn't expect the same productivity. If there is no measured mile, contractors might look to other similar projects or to industry standards. But again, that's not bulletproof because you can always point to differences, why the project was different. And that brings me to the last key element, which is the causation. So you have to show that your loss of productivity was actually caused by the event you're complaining about and not something else, mismanagement, manpower issues. And here the key is to have a very detailed project or record. So it's not enough to have, a letter from the contractor saying you're late with the design. You also need contemporaneous records about how the contractor had to change its work plan, if it moved forward with something else while it was waiting, and the additional costs that it incurred. Now, obviously, the employer's main line of defense is going to say, no, it's the contractor's fault. Look, they were poorly managing, they were having supply issues, manpower issues, et cetera. So it's also going to be, defensive, saying why those weren't the reason that caused the loss of productivity and whatever you're complaining of is. A question that comes up in disruption claims a lot is whether you can make a global claim. And that's basically saying, okay, there was disruption event X, Y, and Z. We thought this was going to cost us 20 million. It cost us 30 million. So therefore, the extra 10 million is because of X, Y, and Z. Now, I'm sure all of you can imagine all the problems with that. You don't have to be a construction expert to see where you could argue against such an approach. So you really should only do that if that's the only option, if there aren't project records. And there's no reason you can't bring that. It's accepted in English law in US and in civil law jurisdictions, but it is going to be difficult to convince the tribunal. Although I will say, I think tribunals tend to be more sympathetic to this if it's clear that the employer is in the wrong. They didn't do something big they were supposed to do, then I think tribunals are a little more flexible in how you're proving your loss.
Thank you, China. Yeah, I think that is true. And yeah, tribunals faced with contractors having multiple disruptive events that are clearly shown, might be a little bit more willing to grant some costs in that scenario, even if it's set out on a global basis. And so with that, we'll go back to Irina and Sean.
Thanks, Anya. I'm seeing some very good questions in the Q&A, which we'll turn to in a moment. But before we do, I will go to Sean. And obviously, we now heard about delay, about disruption from Nader in China. So, Sean, can I ask you, in what circumstances might a contractor decide to accelerate the works? And is it always in the context of a delay, or could there be any other reasons for accelerating?
Thanks, Irina. I think of the different types of claims that we've heard of so far, acceleration is probably the least common. It's much less common than a claim for time, a claim for time-related costs, or for a disruption claim. It can and usually arises in circumstances where there has been some delay, because it's essentially an exercise where the work has to be carried out in a compressed time frame. So whatever time frame you thought you had, it's being shortened, and yet the work has to be carried out within that time. So it could be that the project commencement is delayed. So in Stephen's scenario, you have a delayed handover. It could be because of a delay, and it could be a combination of events, and blame could be attributable across the various actors. It could also be just because the employer has decided they want an earlier completion date for some reason. And so therefore the time frame in which the works have to be carried out is reduced. So it's usually delayed, but it doesn't have to be.
Thanks, Sean. So perhaps you could also tell us about the difference between concepts such as constructive acceleration, as we call it, versus instructed acceleration, and how those can play out in different jurisdictions.
Okay, well, there is, of course, a difference as to how the acceleration comes about. But I think this breaks down into two sections. First, how it occurs and what it is, and so you can identify it. But secondly, I think the way that you might deal with the contractual documentation upon which you're going to rely in support of your claim is also different depending on whether it's constructive or it's instructed. Typically, constructive acceleration will occur where you may have delayed as a contractor. If you've delayed and you acknowledge and recognize that you've delayed and recognize that in order to catch up, you will have to deploy additional resources and perhaps change methodologies. So that isn't necessarily instructed by the employer, although you probably have to agree the catch-up plan with them. But it's something that you've caused yourself and you're having to deal with and remedy. It could also be constructive delays also if, for instance, you've applied for an extension of time and it's been refused, and you're faced with having to complete the works within the original time without that extension. Then again, you're having to put in place accelerative measures to ensure that you can comply with the original timeframes. But when it comes to instructed acceleration, I think the most important thing is to make sure at the time that everything is properly documented. So an acceleration may be dealt with in the standard terms, but often it's dealt with as a separate agreement to the main contract and an addendum. And it should set out clearly what the acceleration relates to. Now, that is not just in terms of time, but it should indicate when it should start and when it should stop. It also needs to indicate whether the acceleration applies to the whole scope of the works, or it may just apply to some. There's also questions that you might ask, such as if in carrying out the accelerated measures, you've had to change methodology in some way, and whether when you decelerate again, it's actually practical to go back to the original methodology, or whether you will have to look at a new methodology or stick with the acceleration. It sometimes becomes more expensive to slow down again. That can be the effect. But acceleration claims are quite advanced, and as I've said, they crop up less often and they need to be dealt with particularly carefully. There's at least two reasons. One of them is that it's very difficult after the event to put together the documentation that you need in support of your acceleration claim. And that means an acceleration claim is different from a time claim or a time-related costs claim, where you can usually construct your claim from the historical correspondence and some of the other reports that were being completed at the time. When you put forward an acceleration claim, you need to be able to establish the additional resources that were deployed in order to catch up. Now, that means doing a comparison between what you were supposed to deploy and what was actually deployed in order to catch up. But it doesn't stop there, because as you keep adding the resources, you tend overall to get less efficiency. So what you have is a disruption claim coming in. And often one of the mistakes that's made in claims put forward by contractors is that there's an overlap between the acceleration claim and the disruption claim. And so you're attempting for a double recovery. Because remember, construction contracts by their nature are a combination of claims, or the construction disputes are a combination of claims. You often have claims with certain variations being claimed for, extensions of time, time-related costs, disruption, and acceleration. So you could have a whole host, and you have to make sure that there isn't an overlap there. And so it does take particular care in preparation. And not all contractor teams and employees have experience of the type of documents that you need to record to be able to recover successfully. So I think there's a combination of in-house training that's required, and on the lawyers in particular, once you get wind of a potential acceleration event being required, you need to get involved to make sure that things are set out properly so that you don't have problems later, because the focus of the engineer, the focus of the employer is just to do it. They'll say yes to anything, You just have to get on with it and finish the contract, finish the project on time. But you need to make sure that you're going to be paid for the extra resources and work that you've deployed. So those are some high-level points that I'd make in relation to acceleration claims.
Thank you very much, Sean. I'll probably then hand over back to Anya for the next questions, unless there is something else you want to add in terms of acceleration.
No, I think we'll move right on to hear from
okay.
Stephen again, and ask him to tell us about the owner's point of view, or the employer's point of view, because we've heard a lot now, mainly from the contractor's point of view on delay, disruption, and acceleration. So does an owner typically have its own claims when faced with a delay or a disruptive event, and how is this dealt with in standard contract terms?
Right. Just a few thoughts before I jump in, mostly to Sean, which is excellent. And it's tempting to think that we can just throw workers at a task. Maybe if you're painting, perhaps from China's example of a road, maybe you can add more crews, but there are limited ways to increase productivity. It just times when you have people on top of each other, you can't do it. From the owner's point of view, well, my experience is that the owners always want to grab the time. In my initial example, I gave the 90 days of open time. The owners almost always will say, that's our time, that's not your time. So if we're slow on approving the windows or approving, I think China gave the example of unforeseen conditions. If something happens, the owners want to claim it. So it's usually the case, Anya, where the owners will not refuse, but are slow to allow the contractor to claim any of that time. Now, if the contractors get to it first, I'm using time and float of the 90 days, it's different. So almost always it's going to be the opinion of, you, the contractors, are going to owe us for that 10 days of lost rent. Or in China's example, maybe it's a toll road and they've lost revenue from the toll. So they're very slow, well, understandably, but it's the flow of money and they're slow to allow it. I'm not sure if that answered your question.
No, that does, and I think I mean, I don't know if you want to say a word on liquidated damages or also called delay damages, but
Sure.
That's also sometimes provided for under the contract.
Right. So I'll go back 20 years ago, and so liquidated damage is a measure in advance of a delay, usually expressed per day, maybe per week. There was a time, and my examples are the US, when liquidated damages were not in favor. Contractors didn't want to agree to them. There's a famous case called Perini, and I forget the general contractor. I mean, Perini was the contractor building a casino. Perini was late, did not agree to liquidated damages. A casino has a tremendous amount of revenue per day, and Perini got crushed in the delay claim. They were at fault, and the damages were astronomical. That changed the tide, where most general contractors now are willing to agree to liquidated damages. Of course, there are fights and negotiations on the dollar amount. Maybe there's a grace period, and it should be accurate. There are all kinds of cases that we can't go into now about the reasonable amount. So expressed as, for instance, $1,750 to $1,750 per day for late. So at least the general contractor can calculate its exposure on a delay and make decisions accordingly. Is it worth spending $1,000 extra on staffing and subcontractor per day? And the answer would be sure, of course, that makes sense. So the idea of liquidated damages is a knowledge of what the per day cost is. Any other thoughts on it?
No, perfect. Also, as a last word from you, from an arbitrator standpoint, what should we be looking out for when we see delay, disruption, and acceleration claims, and maybe made all at the same time or separately?
Sure. I think Nader talked about concurrent delays. It's rare that we're going to have one party, I don't know, at fault or owning the delay. There could be weather, unforeseen conditions. I guess the first is I'd like to know as arbitrator what happened. And secondly, it's a great part of the training in general contracting is the administrative and the documents. What do the documents show? Did the superintendent every day talk about or write down the weather? So I want to know, as an arbitrator, I want to see the trail of documents. In my window example, did the general contractor send to the architect, we need to know now what kind of windows you're approving? And did the architect reply? So I want to see, I'd like to see detailed and try and suss out the schedule and what exactly happened. I also want to see who, and again, back to my example of the 90 days, who used those 90 days first. All kinds of provisions. We've had a lot of discussions in the chat over different laws and how you analyze the delays. And owners are going to be trying to grab it, but it's usually going to be who used the delay first. Was the architect slow? Was there bad weather? I'd like to know what happened and in what order as an initial take on any matter that I'm looking at.
Yes, because these are all very fact-sensitive
always
issues, and it's going to all depend on what evidence can be presented to show it.
Right. It's not going to get to It's not going to get to arbitration if it's a simple case of someone was late. I mean, there'll be arguments about the amount, but that's not going to get to arbitration. I don't think it's going to get to arbitration when it's complex and concurrent events.
Yes, absolutely, and often difficult to show. So maybe Irina, I don't know if you've picked up some questions from the chat that we can throw at our panelists. I'll let you choose one.
Yes, thank you, Anya. I think we've got like 7 minutes left, so we'll try to have 2 or 3 questions. So I'm picking the ones that I feel the most interesting. So let's go with number 1. And I don't know, Nader, I will put you on the spot perhaps here. Do standard forms of contracts specify the method of delay analysis? And if not, how do you go about in determining or agreeing the appropriate method of analysis that is agreeable between the parties? And I think that's often cause of dispute on its own. So perhaps, Nader, you want to take this one?
Yeah, this is a really good question, because sometimes we expect the contract will just say everything and describe how the delay will be done, the delay analysis. However, the contract is, most of the cases, silent, because it will not name a specific method as used in the Society and Construction Law Protocol or any other best practices documents. But we will be able to look for some guidance in the contract itself. For example, is the contract pro or against determining the extension of time as we go on, or is it based on a wait and see approach? Does the contract allow the assessment as well as granting an extension of time to take place before the project or the works are completed or not? So when we will take these guidance and put it together, we will also look for something related to the schedule and criticality. What is the language used in drafting the contract? Does the contract say the contractor, for instance, will be entitled to an extension of time if the delay happens, or if it will happen, or is/will? All of these keys or clues could be used into tailoring what the contract envisages, and we will be able to say, yes, it's a forward-looking approach, it's a contemporaneous determination of the critical path. We don't need to wait and see until the end of the project, because criticality changes from time to time, and it's important to understand what the contract supports, When we will read the guidance and put it together, we will be able to tailor the proper delay analysis. Some other contracts, if you're lucky, will tell you, I would like you to use an observational technique, or will use something to dictate an as-built versus as-planned method of analysis, something like that. But that's usually what we find in our contracts.
Thank you very much, Nader. That was very detailed. So the next one, I think let us talk about disruption. Maybe China, if you like to pick this one up. So there is a general duty to mitigate delay for a disruption claim. That's how the question is put. If a disruptive event was originally not on critical path and the contractor mitigated a possible delay from impacting on critical path by accelerating, does the recovery of acceleration costs have to be a standalone, or does it have to be together with the disruption cost? Basically, how do you particularize your claim in this specific scenario?
Thanks. I think that Sean already touched on this a little bit in what he was explaining, that there is an overlap, and that's okay. When you're explaining your claim, you can explain both aspects of it, but what you want to be very careful about, and what you want to make sure you're working, especially with your quantum expert, to be very careful about, is that, as Sean said, that you're not claiming double recovery. So I think in this scenario, if the contractor on its own initiative accelerates to mitigate delay, then this would be what Sean was explaining is constructive acceleration. And there, I think what is very important is that the contractor, if during the project, if in my example of the apartment building and the office building, if the contractor says, okay, I see that the employer is going to be late on the design of the office building, so I'm going to finish everything to do with the apartment buildings, and they're doing that on their own initiative, they need to send letters to the employer about that. They can't just do it and then later say, oh, that was us mitigating delay and we incurred additional costs. They need to be very clear. Okay, this is a potential claim. We're going to have to change our baseline program, and make sure that there's a record of that. I don't know if that answered the question. Basically, you, as your claim, you can say we accelerated because of this disruption event, but you can't then claim disruption costs and acceleration costs.
Thank you, China. There is one interesting question about supply chain delays in the US. I'll leave this last for Stephen, but before we do, there is one perhaps I will direct to Sean about acceleration. So the question is, do acceleration claims have to rely on the delay expert's opinion regarding what acceleration measures were put in place, when did it happen, and what resources were involved?
Okay, well, I wish there was an easy answer, but it depends on how you are putting your acceleration claim. The acceleration claim could, for instance, be based on purely on an agreement and the interpretation of an agreement, which contains everything that you need to do and you need to spend and how long you need to do it for. But there may be some other inconsistency. For instance, whether all of your claims needed to be substantiated, or whether there was a minimum payment that was to be due, or whether there was a lump sum that was offered in order to complete the acceleration works, or if there was a bonus if you managed to achieve the timelines by a certain date. So it could be based on a contract. Typically, if everything is in dispute, then not only will you need a delay expert or a programming expert, but you will also need a quantum expert to look at the cost of each of the measures that you took place, whilst the programming expert is going to look at a combination of what you did over and above what you were intending to do under the original baseline program, and also looking at whether and the extent to which the measures that you took had the intended effect of accelerating and making up that time in the relevant part of the overall program. So yes, it could involve delay expert. It's likely to involve a quantum expert, but it could be also based on documentation. That could be the argument.
Thanks so much, Sean. Right, just one last one, so we're fair with everybody. For Stephen. So how are the supply chain delays treated, especially if they're similar to the current supply chain problems in US ports in LA and San Francisco?
Yeah, that's a great question. I guess the simple answer is it's a risk of general contracting and subcontracting. There have been past cases where steel is in high demand in China when you can't get it in the US. There was the tsunami, terrible tragedy in Japan that caused delays in the US. And now with COVID and the end of the pandemic with the supply chain, the simple starting point is that it's a risk of contracting. Now, we've had lots of discussions, both academic, scholarly conferences, and in practice of force majeure and impossibility. Those are high measures in the US, and I would imagine in common law. Is it impossible to get the supply, or is it difficult and costly? But I think as a starting point, it's going to be a risk, a financial risk to the contractor without other factors coming into play that rise to it's impossible. It's not just impractical and costly, it's impossible. The ships are off the coast of LA and are not coming in. That's my quicker answer.
Thanks so much, Stephen. Right, we are actually overrunning a little bit by a couple of minutes. So unfortunately, we can't tackle all of the questions in the chat, but thank you very much for all of you who submitted your questions. And thank you for attending the webinar today. I also would like to thank ICDR for hosting the webinar. So thanks to Rafael and Louise, of course. And this, I think, has been a beautiful series of webinars organized by ICDR Young and International. Thank you to all of our panelists, Sean, China, Stephen, and Nader, and to my amazing co-panelist, co-moderator, Anya, for doing all the hard work behind the scenes on organizing this webinar. So thanks a lot for attending, and we hope to see you for our future events.
Thank you.
Yes, thank you all very much.
Good night.